The respondent, having pointed to the repealed Section 195 as the legal basis for his misgivings with his trial before the General Court Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the late judgment, I find that the Constitution of the General Court Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction and is to that extent inconsistent with Article 38(1) and 44(c) of the Constitution. In the result, I will resolve ground 2 of this appeal in the negative. On the other hand, ground 3 of the appeal, under ground 3 of the appeal, the respondent's arraignment before the General Court Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offence as contemplated under Section 117(1)(g) of the UPDF Act. As was earlier observed herein, a person that aids or abets another in the commission of an offence is deemed to have taken part in the commission of the offence and, if proved, will be guilty of that offence. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing the Kawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)(g), 117, that is 117, 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offence is stated as offences relating to security, contrary to Section 131(8) of the UPDF Act, while the particulars of offence indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Luweero districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offence. This would indeed amount to a defect. However, not every defect in a charge sheet would make it barred in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offence, the respondent would have been on notice of the nature of offence he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a civilly subordinate court, that option of amendment of the charge would have been available to the General Court Martial to clarify the specific role played by the respondent in the alleged offence, as well as demarcate who of the persons he was arraigning were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court Martial a violation of the right to a fair trial. However, given the then de jure composition of the General Court Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith v. Kentucky, the U.S. Supreme Court reiterated its view in United States v. Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Novea v. Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Novea v. Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith v. Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Spector v. Canada. That case was relied upon in Fish-Erickson in the article Choosing Constitutional Remedies by Fish-Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competency in the membership of the General Court Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals to fill courts-martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defense Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SACTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform therein, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily an issue before this court. It might similarly accrue to the right to a fair trial in courts-martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial autonomy. Disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the new judgment. In the result, I will set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)b and 257(1)(b of the Constitution, but its de jure membership under Section 195 of the UPDF Act does undermine its independence and impartiality, and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondents are raising before a general court-martial that the jury membership of which does not pass constitutional muster was a violation of his right to a fair trial, and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3. The provisions of Section 117(1)(g of the UPDF Act do delineate exceptional circumstances that will justify the trial of civilians in military courts, and is to that extent consistent with the right to a fair trial as enshrined in Articles 28(1) and 44(c) of the Constitution. 4. Section 117(1)(h) of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court-Martial in light with Order 2 above. Respectfully propose the following additional advisory order for consideration. The General Court-Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order. Article 28(1) of the Ugandan Constitution, as similarly expressed in various international covenants, the pertinent one for present purposes being the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee has since pronounced itself on Article 14 of the ICCPR in its General Comment number 13 of 1984 and General Comment number 32 of 2007. General Comment number 13 proposes that the trial of civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006 supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offences in question. That is the universally established command of Article 14 of the ICCPR. Courts-martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offences defined in Section 1 of the UPDF Act, which include the offences enshrined in Part 6 of that Act. The intricate nature of the service offences they preside over supports the view that the primary function of courts-martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court-Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshave, where this court adjourned the General Court Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court Martial under the UPDF Act and conferred it with criminal jurisdiction over non-military persons and civil offenses. Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order, and good governance. Article 210(a) and (b) further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offense in Section 1 of the UPDF Act would encompass the offenses created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offenses under any other act that are committed by the same category of persons. Hence, the scope of service offenses in question restricts the inclusion of civil offenses to those cases where the civil offenses are committed by persons that are in active military service as delineated under Section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offenses in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court Martial over civil offenses. I do acknowledge the position taken in Attorney General versus Joseph Tumshave that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offenses by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts martial in presiding over offenses committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offense translating into a service offense, whether committed within or outside Uganda. I am alive to the character of courts martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts, or indeed other courts martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of field court martial when in Article 137.5, it exempts their processes from constitutional references. In those circumstances, closing such field courts-martial with jurisdiction over capital offenses that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts-martials to non-capital civil offenses would be to leave capital offenses that are committed in those sometimes fluid situations uncatered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts-martial, which by extension would include field courts-martial. Accordingly, the right of appeal from the decision of a field court-martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts-martial operate do provide sufficient justification for their jurisdiction to try civil offenses, including capital offenses. Having appeal over decisions of field courts-martial, I would refrain from excluding civil capital offenses from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3.4 of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offenses delineated in Part 6 of the Act would be deemed to have taken part in committing the offense, be guilty of the offense if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime, but the particulars of the offense must clearly indicate the role of the aider and abetter. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offense is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offense warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offenses encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed that is an offense under both service law and the ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murders, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases. Close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offense on the one hand, and a service offense that is also available as a civil offense. In addition, though seemingly restricted to capital offenses, I would extend it to non-capital offenses that accrue as both service offenses and civil offenses. In my view, therefore, the general rule ought to be that military service offenses are only triable in military courts, and civil offenses are only triable in civil courts, save for two exceptions: the trial by field courts-martial of military persons that commit civil offenses during field operations, and the trial of service offenses by civil courts, where such offenses do also exist on the ordinary criminal law statute books. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offense do by their actions subject themselves to military law under Section 117(1)G of the Act. 171H, on the other hand, subjects to military law any person found in a lawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores, so as to avoid the prohibited conduct. Article 28(12) of the Constitution considers a criminal offense that is not adequately defined to undermine the right to a fair trial, and thus prohibits convictions arising from vague and ambiguous criminal offenses. The need for a precise definition of an offense is associated with the principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited, and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)H of the Constitution. In the result, I find that service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)G of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)H of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle of judicial independence, which in the Ugandan Constitution is articulated in Article 128. In the same vein, Principle 13 of the Draft Principles on Military Tribunals proposes, I quote, "The organization and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings. The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy." Close quote. The UN Human Rights Committee additionally enjoins states to take all necessary measures to ensure that such trials take place under conditions which genuinely afford the full guarantees as stipulated in Article 14. The African Commission of Human and People's Rights has similarly adopted the stance that military tribunals must be subject to the same requirements of fairness, openness, and justice, independence, and due process as any other process. Thus, in the Constitutional Rights Project versus Nigeria, it decided that a tribunal comprised of one judge and members of the armed forces could not be considered impartial because regardless of the character of the individual members of such tribunals, its composition alone creates the appearance, if not of impartiality and bias. Close quotes. The General Court Martial of Uganda was established under Section 195 of the UPDF Act. It is composed of 7 members, all of whom are appointed by the High Command for a period of 1 year, subject to reappointment by the same appointing authority. Its membership is solely comprised of military persons, with no provision whatsoever for their professional qualifications, neither are such qualifications provided for its reserve members. Therefore, although at any one time the actual members of the General Court Martial could very well possess the requisite qualifications, its de jure composition is purely restricted to qualification on the basis of military service. In Inkawa versus Turkey, the European Court of Human Rights, the European Court of Human Rights highlighted the specific factors that would be taken into account in determining the impartiality and independence of military judges. The court astutely identified the crux of the matter as the confidence which courts in a democratic society must inspire in the public, and above all as far as criminal proceedings are concerned, in the appeals. It further deduced the parameters that will support the independence and impartiality of military judges to include the same professional training as civilian judges and the enjoyment of constitutional safeguards identical to those applicable to civilian judges. It additionally expresses concern about military judges being servicemen who still belong to the army, which in turn takes its orders from the executive. And they remain subject to military discipline, and the appointment of these officers is made by army structures for a short renewable term. That decision is most persuasive on the standard of independence and impartiality expected of military judges and military courts. In any event, the concerns expressed in it are re-echoed in Principle 13 of the Draft Principles of Military Tribunals. Paragraph 7 of that draft principle emphasizes